Hello and welcome to our Banking and Finance Academy session on the modernisation of security law in Scotland. Martin, Craig and I will be discussing the recently introduced Moveable Transactions Scotland Bill. So, moving on to the agenda for today's session. We'll briefly set the scene and set out how we got to where we are now. We'll then cover what the current position of the law is, and then following from this, we'll look at the proposed reforms and the potential benefits that these will have for businesses. And then finally, we'll try and answer any questions which have arisen. So moving on to the story so far. Although our timeline begins in 2005, the idea of reforming this area of law goes back much further than this. With no reform aside from the introduction of floating charges in the 1960s, the area of law has been ready for review for some time. The Scottish Law Commission first identified the topic as a potential area for reform during their 7th programme of law reform, which began in 2005. But due to other ongoing projects, namely the report on land registration, the project did not see any substantial work produced until 2011. In June of 2011, the Scottish Law Commission published its first discussion paper on the topic, and there was then a subsequent call for evidence. Due to the size of the project, it was not started until the 9th programme of law reform, which began in 2015, some 10 years after the Scottish Law Commission first identified this as an area for reform. This finally led to the Scottish Law Commission publishing its 3-volume report on movable transactions in Scotland in 2017. This comprised of a volume dedicated to each of assignations and security over movable property. Volume 3 of the report contained a draft bill, which has been used as the basis of the bill subsequently introduced to the Scottish Parliament, although there have been some significant changes, which we'll talk about later on. Following on from the Commission's report, the Scottish Parliament's Economy, Energy and Fair Work Committee heard evidence on the proposed reform. And following a consultation in early 2020, where the committee received written evidence, they published the report summarising the responses. The committee received a range of responses, including from Brodie's, where we strongly supported the implementation of the bill. In September of last year, the bill was included in the Scottish Government's legislative programme for 2021-2022, and then finally, in May of this year, the bill was finally introduced to the Scottish Parliament. Now that the bill has been introduced to the Scottish Parliament, it will begin the parliamentary process. This consists of 3 stages. The bill will be allocated to a committee who will take evidence about the bill, and once this evidence gathering process is completed, the committee will release its Stage 1 report on the bill. The bill will then move to Stage 2, where MSPs can propose amendments to the bill. These will be debated and decided on by the lead committee from Stage 1. Once any amendments are agreed, the bill moves to Stage 3, where it is debated in the debating chamber, where further amendments can be proposed. There's then a vote on whether the bill is to pass, and if successful, the bill will then be sent for royal assent. We expect this process to start shortly, and we'll be monitoring the bill's progress through Parliament and the likely timescales involved on our different social media channels. I'll now hand over to Martin, who will discuss the current position of the law.
Thanks, Ian. So let's first look at the 2 main areas of movable transaction reform insofar as they affect security law in Scotland. Broadly, the 2 areas here are assignations and security and pledges. So looking first at assignations and security, these relate to the creation of security over incorporeal movables. So here we're thinking about things like receivables, such as rental income, other contractual rights, shares in companies, member interest in limited liability partnerships, intellectual property, etc. In order to perfect an assignation security over a contractual right, the right needs to be transferred into the name of the security holder. In order to achieve that, a written hard copy information notice needs to be physically mailed to and received by the relevant counterparty. Similarly, for assets such as intellectual property rights and shares in a company, title to those assets needs to transfer to the security holder in order to create the security. In the context of IP rights, this involves the transfer of the right to the security holder, followed by a licensing arrangement back to the grantor of the security so that it can continue to use and exploit the IP right. In the context of shares in a Scottish company, the security holder or its nominee needs to become the registered shareholder of the Scottish company to perfect the security interest. Now, we could do a full session on the possible issues of the lender becoming a shareholder in this scenario, but for brevity, there are regularly discussions around PSC registration, possible pension liabilities, and the implications of the National Security and Investment Act. Now, there is some doubt under the current law of how effective an assignation by way of security actually is. One of the essential elements to carry out an effective assignation of a claim, right, or asset is that the transferee should have control of it. In a security scenario, it's common for the party creating the security to continue to have the right to receive payments of the assigned debt, or to continue to be able to exercise its rights in relation to the assets prior to an enforcement event. For example, exercising voting rights relating to shares. It is therefore at least questionable whether the requirement for control is satisfied in the context of an assignation in security. And finally here, one of the key challenges of the current law relating to assignations in security is that it is not possible to assign or create fixed security over future rights or assets. The result is that when new rights or assets come into existence, further or supplemental Scottish security is required. I'll give an example of this in the context of real estate and funds finance deals later in the session, though there are many others as well. Moving now to look at the concept of pledge under Scots law, which is sometimes referred to as pawn. In this context, we're thinking about corporeal or physical movable assets, such as vehicles, IT equipment, whisky casks, plant and machinery, etc. This is the only method of creating effective fixed security over corporeal, movable and movable property in Scotland. Whereas for fixed security over land, we have the standard security. There is currently no equivalent for corporeal movable property. To perfect a pledge, physical delivery of the asset to the creditor is required. So in order to create an effective pledge over my laptop, for example, I would need to pass it over to the person extending credit to me. That creates an issue for me though, because I need my laptop in order to generate the money that I'll use to repay the debt. And therein lies the key commercial limitation of the current law of pledge in Scotland. How does the party creating the pledge run its business if it needs to give physical possession of the underlying asset to its creditor? The answer is that assets which are needed to run the business, such as vehicles or plant and machinery, can't, or at least aren't easily, used as effective collateral for raising finance backed by fixed security. Where a pledge is commercially possible, so for example, in relation to whisky casks, which are not required for the day-to-day running of a business, there is some uncertainty under the current law about how effective delivery to the security holder is carried out. Continuing with the example of whisky casks, typically they do not move anywhere, and there is instead a contractual arrangement that certain casks are being held by a warehouse keeper for a security holder instead of the security grantor. While there is long-standing practice in this area, there is a lack of clarity whether this results in effective delivery of the whisky casks to the creditor. From a commercial perspective, really the only method of creating effective security over corporeal movable assets in Scotland is therefore via a floating charge. While this doesn't give the security holder fixed security over assets, it does give them an enforceable security right and the ability to appoint an insolvency practitioner in a breach or insolvency scenario. The key limitations of floating charges, however, are that it can only be granted by limited companies and limited liability partnerships. It's not possible for an individual, such as a sole trader, general partnership or limited partnership, to grant a floating charge. Where a floating charge is possible, the grantor of it is generally free to deal with its assets, and when an asset is disposed of, it's no longer covered by the floating charge. Floating charges are also postponed to certain claims in an insolvency scenario, including to fixed security holders and preferred creditors such as employees and HMRC. So while floating charges are a useful form of security and are used in most deals involving companies and LLPs, their limitations mean that lending on the basis of a floating charge alone is typically more expensive than where effective fixed security options are available. So in summary, the current law on movable transactions in Scotland is widely regarded as being outdated. It's mainly based on old statute and some common law, with the main statute on assignation of claims, for example, dating back to 1862. Much of the current law is either open to interpretation or otherwise lacking in detail, resulting in alternative legal mechanics being used to achieve the desired commercial outcomes. For certain sectors or asset types, there is long-standing reliance on legal workarounds in order to achieve the desired outcome from a security perspective. Examples include the license back of IP rights, as I mentioned before, but also other arrangements such as leasebacks or the use of trusts, which Craig will discuss later in the context of securitisations. This is principally as a result of the need to transfer title, or in the case of movables, physical possession to the security holder to perfect the security, as I mentioned earlier. Those requirements also lead to risks relating to the security holder's position as holder of the right or assets. As I mentioned in the context of the pledges, it can be commercially impractical for businesses to create effective fixed security over assets required for the operation of their business. Together with the limitations of floating security, which I've just discussed, this often results in certain businesses or individuals having fewer or no financing options available to them. When lenders are willing to lend on the back of existing security structures, the rates charged for such financing are often much higher than they might be for other businesses. And the issue is, of course, even more keenly felt in an unsecured financing scenario. So in many ways, the current law works and has done for many years now. However, in many ways it does not, or at least it is no longer fit for purpose in a modern commercial context. So with Ian having talked us through the timeline of the reform project to date, and me having given a whistle-stop tour of the state of the current law, Craig will now look at the reform proposals and how they address some of the issues I've highlighted.
Yeah, thanks, Martin. So having considered the current law in the context of assignations in security and pledges, we'll now take a closer look at the reform proposals themselves by walking through the key provisions of the bill. And this should provide an opportunity to identify how the changes will address many of the issues with the current law that Martin has already highlighted. And we won't have time to cover every aspect of the bill, but I'll seek to highlight the principal changes that are proposed. Firstly, by considering assignations of claims, and then the new statutory pledge security. So part one of the bill deals with assignations of claims. And claims are defined in the bill very broadly as a right to the performance of an obligation, including an obligation not to do something. And so this extends to, for example, debts, accounts, warranties, and others. However, it should be noted that non-monetary rights relating to land or negotiable instruments are expressly excluded from the definition, and claims in respect of wages or salary payable to an individual are also excluded from the bill. So in terms of formal requirements, the bill states that the assignation of a claim requires, firstly, the execution or authentication of a document assigning that claim by the relevant assigning party, and secondly, that the underlying claim is identified within the assignation document itself. Where a number of claims are being assigned, each claim does not need to be separately identified, provided that the relevant claims are identified by their constituting an identifiable class, which itself is referred to in the document. So significantly, the bill states that it's competent for a claim to be assigned where such claim is not held by the assignor at the time the document is granted, and that's whether or not the claim even exists at that time. As such, the bill makes it competent to assign so-called future claims. So if the assignor does not hold title to the claim at the time the assignation document is granted, the relevant transfer will be effected when the assignor becomes holder of that claim, assuming that is that the other requirements relating to creation are met, which themselves are set out at the bottom of this slide. So as it currently stands, Scots law doesn't permit the assignation of future claims, or at least the effectiveness of such an assignation is highly dubious. Now, as Martin's mentioned, the Scottish legal market has historically dealt with this through the grant of further or supplemental assignations. However, as many in the audience will be aware, this can often lead to substantive administrative, registration, and legal expenses where ongoing assignations are required. And there's also a risk factor if the parties involved on such transactions neglect to grant ongoing assignations when they're required to do so. Accordingly, the proposed reforms will substantively modernise this area and will significantly lessen the administrative burden on parties where future claims require to be transferred. The changes proposed in the bill will also make it possible for assignations to be granted such that an underlying claim will only be transferred once a relevant suspensive condition has been satisfied. And the current law in Scotland in respect of so-called conditional assignations is underdeveloped, and the effectiveness of such an assignation is therefore doubtful. The Scottish legal market has often had to cater for this by attaching any conditionality in an assignation to the effective delivery of a document pursuant to the Scottish counterparts legislation, rather than including it in the operative assignation clause itself. This can often lead to divergence in Scots law documents where other jurisdictions are involved in the same transaction, and it also poses issues where a unilateral document is being granted or otherwise where the document isn't being signed in counterpart. The proposed introduction of a statutory rule in respect of conditional assignations therefore provides much needed clarification in this area, and this should deliver additional optionality on a range of different transactions. For example, receivables financing transactions, where conditions for the purchase of the underlying receivables have to be satisfied before the assignation takes effect. The bill also makes substantive and very positive changes to perfection requirements in respect of assignations. As Martin mentioned, an assignation or assignation security is typically perfected by a written hard copy intimation notice being mailed to and received by the relevant counterparty, or otherwise the counterparty signing the assignation document itself by way of acknowledgement. So where English law would often rely on equitable principles to avoid the requirement of serving notice on individual debtors, Scots law doesn't have a similar concept. And so intimation to individual debtors, which on larger transactions can number in the hundreds or even thousands, has provided a substantial administrative hurdle on transactions with a Scottish nexus. The bill introduces a welcome alternative by way of the creation of a public register known as the Register of Assignations. Thus, instead of intimating to individual parties, an assignation may be perfected by registration of the assignation document at the new register. Accordingly, intimation to individual debtors can be avoided, and this is particularly welcome where the underlying debtors are remote from the transaction itself. It also has the potential to cut down greatly on administrative costs. As regards delivery of intimation notices, which is still a potential perfection route, and the bill also makes it possible to serve notices on debtors by transmitting the notice to an email address rather than just postal and hand delivery, and there's often been doubt around this in the past. Again, this is a further positive and modernising change. So now moving on from assignations and assignations in security, Part 2 of the bill deals with the creation of security over movable property, both corporeal and incorporeal. So where the pledge is over corporeal property, the pledge can be created in 3 different ways. Firstly, by the delivery of the charger's property to the secured party. Secondly, if not owned by the charger at the time of delivery, on the property coming to be owned by the charger following delivery of such property. Or thirdly, by registration of such statutory pledge in a new register of statutory pledges. As such, we see a distinction between A, the possessory pledge, and B, the new statutory pledge, which is created by registration in the new register. Separately, if incorporeal property is to be charged, or otherwise where there's to be a mix of corporeal and incorporeal property pledged in one document, only the statutory pledge route can be used. So the possessory pledge restates much of the existing Scottish law surrounding pledges, is created by the physical handing over or the giving of control of the premises in which the pledged property is located to the secured party, or otherwise instructing an independent third party who has direct possession or custody of the property to hold it on behalf of the secured party, or in respect of goods being shipped, delivering a bill of lading in respect of the property to the secured party. However, the statutory pledge breaks new ground as a matter of Scots law, and it significantly broadens the scope of property over which it's commercially viable for security to be taken in Scotland. Whilst the requirement for control has historically curtailed the ability to take security over movable assets, the creation of the new register of statutory pledges removes this requirement. So in terms of what types of property can be subject to a pledge, the category of corporeal property is very broad. For example, plant and machinery, whisky, paintings, motor vehicles and furniture are all covered. However, ships and aircraft are excluded from the new statutory pledge, which should be noted. Regarding incorporeal property, the statutory pledge is currently limited specifically to intellectual property only. And whilst there had been an intention for shares in Scottish companies to be included within the remit of the bill, the Scottish Parliament's decided that they don't have power to legislate in this area. And so they've asked the UK government to grant an order to include shares going forward. So once the relevant order has been granted by the UK government, the scope of the statutory pledge will extend to shares in Scottish companies, which will thereby avoid the current situation of legal ownership in the shares requiring to be actually transferred to the security holder or their nominee. This will in turn allow issues relating to PSC registration, possible pensions liabilities, and the implications of the National Security and Investment Act to be avoided by security holders, and we'll provide updates in relation to the order and the extension of the statutory pledge scope as it develops via our website and media platforms. Similarly to assignations of claims, the bill makes it possible for a statutory pledge to be created over future property. The requirements for the creation of the pledge are that firstly, the property belongs to the provider. Secondly, the statutory pledge is registered. And thirdly, the property is identifiable. The relevant security is only created when each of these requirements are met, regardless of the order in which they occur. As such, the pledge document could identify future property, for example, all computers to be acquired by the company, and then be registered in the newly created register. But the security in respect of such property would only be created at the point the property becomes owned by the security provider. The bill also allows further property to be added to an existing statutory pledge by way of amendment. So, for example, adding all office chairs to be acquired by the company. However, an amendment would then need to be registered at the Register of Statutory Pledges in order for such security to be effectively created.
Thanks for that, Craig. So having been through the proposed reforms, we're now going to run through some examples of how this will benefit businesses by looking at 4 different types of financing, namely real estate financing, asset financing, funds finance, and securitization. Martin's now going to start us off by looking at real estate financing.
Yes, thanks, Dean. So looking first at the current law in real estate finance deals, in an investment financing context, one of the key aspects of the security package is security over rental income generated from tenants of the property. In order to create an assignation security over that rental income, intimation notices currently to be sent to each of the tenants. This can be particularly challenging or often completely impractical in the context of a large shopping centre or student accommodation, where the tenants are numerous and often changing. Also, where new leases are entered into, supplemental assignations and security are currently required. In a development financing context, assignations and security over the various development documents, such as the build contract, are often taken. Again, this requires notice of the creation of the security to be sent to the contractor and can open up questions relating to the control of the underlying contractual rights. The proposed reforms in this context will allow for the creation of fixed security over rental income and rights under development contracts without the need to give notice to tenants or contract counterparties in order to perfect the security interest. With future rights being covered by the day one security, the changing body of tenants and creation of new leases will no longer attract a requirement for supplemental security. And finally, clarification of the law related to control will also make fixed security in this context much clearer. Craig, what about some of the likely benefits from an asset finance perspective?
Yeah, thanks, Martin. So as highlighted earlier, one of the key issues with the current law relating to security over corporeal movable property is that to create the security, control of the assets requires to be ceded, which generally requires physical delivery of the relevant asset to the security holder or its nominee. So subject to certain limited workarounds that have been developed in respect of certain assets, for example, we've covered the context of whiskey casks, whereby security is created by control of the casks being passed to a third party who's undertaken to maintain and protect the assets for the benefit of the security holder. The control requirement has served to prohibit the vast majority of corporeal movable assets from being made subject to Scottish security due to the required use in the day-to-day running of businesses for borrower and guarantor entities. Accordingly, the scope for collateral over corporeal movable property has by and large been limited to floating security over assets in the past. So the statutory pledge regime therefore brings much positive change. So whilst a so-called possessory pledge may still be used, the statutory pledge doesn't require the same control to be exercised. Instead, the requirements to create security will be fulfilled by, firstly, the property being owned by the charger, secondly, the property being identified in the pledge, and then thirdly, the property being registered in the new Register of Pledges. As such, it will become feasible for corporeal movable property that is used for the day-to-day running of a business. So for example, computers, a fleet of motor vehicles, plant and machinery, or furniture to be made subject to security. This presents a really positive development over the current law for both lenders and borrowers, as it expands the scope of collateral available to lenders as part of a security package, and also makes it feasible for a lender to take collateral over corporeal movable property that the lender itself is financing the acquisition of, whilst it also avoids a borrower's business being interfered with by assets being handed over to the lender. Martin, could you tell us a bit more about how the proposals will affect funds finance?
Of course, thanks, Craig. So the most common type of security taken on funds finance deals with a Scottish aspect are assignations in security of the right to issue capital call notices to investors, or assignations in security of limited partner or general partner interest in Scottish limited partnerships. As I mentioned earlier, in order to perfect such security interests, the secured assets need to be transferred to the security holder. This can lead to questions around the timing of exercise of capital call rights, or risks relating to the security holder potentially becoming a partner of the underlying limited partnership and having liabilities to the fund. Also, in order to perfect an assignation in security of capital call rights, an intimation notice must be sent to each investor, which can be a substantial undertaking in many cases. A further point in the context of assignation of capital call rights is, as a result of it not being possible to assign future rights, in the event future investors come into the fund on later closings, supplemental security and notices will be required in relation to the rights to issue capital call notices to those further investors. Under the reform proposals, it will be possible to create an effective assignation over capital call rights by registration in the new Register of Assignations without the need to issue intimation notices to investors. When intimation notices are an acceptable method of perfecting the security, the law will be clarified such that it will be possible to issue intimations electronically. In relation to security over general or limited partner interests, the new law can also be used. This will remove the risks of security holder unintentionally becoming the general partner or limited partner of the limited partnership. Finally, as we've mentioned, the new law will extend the creation of security to cover future rights, meaning that supplemental security and notices will no longer be required in this context either, thus reducing costs. And Craig, finally back to you on securitisations.
Yeah, thank you. So securitization and warehouse financing transactions are one of the transaction types that have the potential to benefit greatly from the proposed changes outlined in the bill. So firstly, and considering transactions where sales are affected by way of equitable sale arrangements, so this diagram on the slide shows a simplified securitization structure. As you'll see, the transfer of Scottish receivables sold under the usually English law governed sale agreement are implemented by way of the entry into of a Scottish declaration of trust. And then if portfolio originations are ongoing, supplemental declarations of trust also required to be entered into. While security over the English receivables is then usually implemented in the form of a single deed of charge or security agreement, continuing portfolio originations require assignations in security to be granted on an ongoing basis, and that's in addition to an assignation in security being granted at closing, in order to actually capture the Scottish receivables subject to the ongoing Scottish declarations of trust. And these assignations in security generally require the issuer, originator, and security trustee to be party to all of them. So under the new proposals, it'll be possible for a single assignation in security to be entered into at the outset of the transaction, which can capture the rights under any Scottish declarations of trust granted in the future. As such, the administrative burden of entering into ongoing Scottish security is greatly reduced. For example, the security trustee shouldn't require to enter into any ongoing Scottish specific documents, and in the event that the issuer is a UK entity, ongoing security registrations at Companies House will also not be required. Meanwhile, financings affected by way of legal title transfer rather than equitable sale will be greatly simplified as the bill permits the grant of assignations. So speaking about legal transfers here, and assignations in security in respect of future assets, which currently isn't possible under Scots law. And so a single assignation document would require to be entered into at the outset of the transaction, which would cover both present and future Scottish receivables, i.e. there should be no requirement to grant ongoing assignation documents going forward. So it's a very exciting time for securitization transactions with Scottish elements. And if anyone does have any additional queries on this following the close of today's session, we have a specialist securitisation team here at Brodie's who'd be very happy to assist. I'll now hand back on over to Ian, who will bring us to a close.
Yeah, thanks, Craig. So we've had a few questions come through, so we'll try get through a couple of these now. So firstly, what should businesses be doing now?
I'll have a shot at this one. So I think like the rest of us, yeah, you should be keeping an eye on the bill's progress through Parliament, and also keeping an eye on any amendments that might be made which will impact the potential benefits for businesses. We've already mentioned the extension to include shares, which is expected. So Brodie's and the rest of the Scottish legal market will be watching this really closely over the coming weeks and months. And yeah, ourselves will be providing regular updates through our blogs and other kind of media platforms to give businesses additional insight into what's happening. But yeah, if anyone has any queries on that in the meantime, please do just get in touch with one of us or your usual Brodie's contact.
That's great, thanks, Craig. And we'll go for one more. Who will be the main beneficiaries from the reform?
Thanks, I'll take that one. But I suppose there's a bit of horizon scanning on that question, really. But in general, it's quite clear to us that there'll be benefits for many sectors and businesses. We've, of course, touched on some of those in the session, but there are others as well. If I was to make a general comment about who will benefit the most from the reforms, I think it will be those who are currently affected by having fewer or no financing options available to them, or possibly financing options that are expensive or complicated than they might be in other jurisdictions. I guess that answer sort of transcends sectors, so maybe doesn't answer the question directly, but I think it's a neat way of summing up one of the key driving forces behind the reform project.
That's great. Thanks, Martin. So a quick note on our next Banking and Finance Academy, which will be happening in September. And this will be focusing on the latest trends and topics relating to regulation in the financial services industry. So if you can come along, then please do. And that now brings us to the end of the webinar. So thank you for attending. And when leaving the webinar, you'll be prompted with a short survey. So any feedback would be greatly appreciated. So thanks again for coming.